Hello, and welcome to today's webinar, Employee Handbooks Do's and Don'ts, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will try to work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions throughout the presentation. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory preventing harassment training in English 3 times a year. With that, let's begin today's webinar, Employee Handbook Do's and Don'ts. Today's interactive session will be run by CJ Westrick. CJ Westrick is an SPHR and has been in human resources management for over 25 years and received her SPHR, which is Senior Professional in Human Resources, her national certification, in 2002. She started HR Jungle in 2006 and targets companies that want senior level HR expertise on a part-time basis. HR Jungle provides business owners and management teams workable solutions and hands-on assistance with employees and legal compliance through outsourced HR services. Thank you, CJ, and welcome today.
Thank you, Deb. And today we're going to be talking, obviously, employee handbooks. We're going to be reviewing some of the policies, talk about where your employees are located, and various documentation and training. And I often like to start my webinars with little news flashes and just things that hopefully are relevant to the topic. This is an article that was about, or lawsuit, Applied Vacuum Technology, that had terminated an employee on medical leave for not calling in every day. And so what it turned out was that in their handbook, they didn't have it written up properly. And so the order, or what the courts required them to do, is within 6 months, they needed to have an employee handbook with its workplace policies on the consequences of not reporting into work daily, such as, since this person got fired, to say you may be terminated if you don't do this, workplace discrimination and harassment, and how to request a reasonable accommodation for disability. In addition, they were expected to hold all employee meetings to explain the policies in the handbooks, and they had to train all their employees on discrimination on the basis of disability and retaliation, and those had to be introduced by the president or CEO. This is like an EEOC kind of lawsuit. I have found the EEOC to be adding not just financial, fees and fines and stuff like that. It's that they're forcing workplaces to change by having the courts demand this as part of the restitution. Another one, this is a little older, Cheaters. It was a TV show that had 2 female office assistants who were sexually harassed. They didn't have an employee handbook or a policy explaining the procedure for reporting the conduct. So in their case, for 2 years, they have to supplement their employee handbook to include an alternate avenue for making complaints where an employee is uncomfortable reporting conduct through the internal process. They have to provide annual anti-sexual harassment training to all employees, including managers, and they have to post a notice of non-discrimination on the employee bulletin boards, and they have to notify the EEOC each time they receive a complaint of sexual harassment from one of their employees. So again, you can see where the EEOC is forcing change by having things that they actually must do rather than just throw some money at it. I've seen this more and more in the last few years that the EEOC has been looking for part of the, we'll call it fine, to be actual things to be done. So we're going to jump right into our first polling question, Deb.
All right, here we go. So, do you have an employee handbook or written policies? Select either employee handbook, written policies, or nothing in writing. And I like to make sure that we've got at least 75% of the people voting. So if you're thinking about not voting, you're just holding up everything. So go ahead and vote. It's keeping you interactive and experiential here. So makes it a little bit more interesting for everyone. And you did a great job. So CJ, 76% say employee handbook, 19% say written policies, and 5% say nothing in writing.
All right. Now, the thing to keep in mind is an employee handbook isn't legally required. However, depending on what state you're in and how big you're getting, it's highly recommended a lot of times, mostly because it pulls everything together into one document. And that way, everybody's getting the same information. Some states have certain policies, like California now, you have to, even if you have no handbook, you have to have a written policy on sexual harassment prevention, and often even on our paid sick leave that the state requires. So, keep in mind that nothing isn't always workable. But also, if you don't have it in writing, it's harder to fire people. It's harder to have any kind of disciplinary action because you can't say they're doing it wrong if you don't have proof that they were told how to do it correctly. So normally an employee handbook, it's a reference for the employment laws and your general policies. And one thing I find, because we do a lot of employee handbooks, my company does a lot of employee handbooks throughout the year, and we do a lot of updates for people that maybe had one from someone else. And the one thing I find, not in my handbooks, but in the other ones that someone's created for them, is that they will also say, call Sam, if you have a sexual harassment complaint. And, and the problem is that people come and go in a company. And so then using a name is never advised. Use their title, because their title is what the position is that you're reporting it to. And that isn't going to change as much. I mean, it might change if you were using like office manager, now you actually have an HR manager, but that's more easily updated and known than saying, oh, Samantha Jones, and everybody's like, who's Samantha Jones? I've never heard of her. So you need to kind of think it through, that this isn't just for the moment. I've seen some of my clients, they don't update their handbook like for years. I'll get one, that's like right now, that's like from, okay, I think the last date we have is 2014. And it's like, okay, there's a lot of changes that have happened since then. Not everything that legally gets changes ended up in your handbook, but you also just your general policies and how you do things might change that require you to update your handbook. I don't recommend adding much in the way of what I call operational details, like the step-by-step for expense reimbursement, or what a supervisor does with a time off request. I might say it's like, yes, submit the time off request to your supervisor, but then I'm going to have something else that tells the supervisor what to do. And the same with expense reimbursement. It's like I'll put as much as you must, provide backup for your expenses and submit it before the end of the month to accounting department. But I don't get into how do you fill out the expense report, all that kind of stuff, because that kind of thing changes often too frequently to put it in a handbook, and it just adds a lot more pages. And as you know, if you've got the type of employee base that needs printed copies of handbooks as opposed to digital, it can be very expensive these days to print out, a 100-page handbook for 100 people. So, make sure that what you're putting in there isn't something that's going to keep changing every quarter. When you're talking about the detailed how-tos, to me, that's more of an operations manual. There's different names for it. Some companies, depending on the industry you're in, might be SOPs, standard operating procedures. Supervisor manuals might be good for giving supervisors specific guidance, but I find very few companies doing a supervisor manual. Usually you can do the same thing with training, which I think actually gets through a little better, because the supervisor manual would have to be changed so often based on things that are changing out there. But I do, if a company's doing something like that, if you've got an operations manual, if you have SOPs, I will reference them in the handbook and say, it's like, for more details, look at this, review the operations manual or something like that, because I have had clients that do an operations manual that give very specific, here's exactly. And part of that's because they have a lot of people that interchange jobs. And so it's kind of like the front desk manual when, as whoever's acting as your receptionist, a manual that, so that anybody that's having to cover for that desk or that person has something to review to know how to deal with certain situations. So it's really nice to have something like that. I find few companies have them, but it's really great when you do, because it's very useful, and it also helps when you're having to hire new people that they've got some reference to look at. Moving on to our second polling question.
All right, here we go. Have you trained managers on your harassment policy? Yes, no, or we don't have a policy. And CJ, we have one question that came up, and I'm sure you're going to get to this, but I'm going to ask it anyway. How often should handbooks be updated?
I will get to that, but I think they should at least be looked at annually.
Okay.
And so typically keep notes of what changes you might want to do to it, and then do it annually. I think, unless you're in a very changing environment, that's usually good enough. It may not even need changes annually, but you need to review it that frequently.
All right. And in our poll, we have a whopping 71% say yes, 21% say no, and 8% say we don't have a policy.
Well, and out of that 71%, I'd be curious to know how many of those people, we don't have that question out there, but are from California. Thanks to the Me Too movement a couple of years ago, California specifically put, I think it was like 8 new laws on the books regarding harassment. And some of them felt like they were repetitive based on laws we already had in place. But one of them was, and California for years it had a policy already in place that said that anyone in a supervisory position had to be trained every 2 years. And the new law said now non-supervisory have to be trained every 2 years also. It's just a difference of non-supervisory is a 1-hour program, supervisory is a 2-hour program. So California requires it legally, but other states have some of that too. And because thanks to the Me Too movement, there were a lot of states that instituted policies about harassment training or just updated their laws, things like that. So, and it really does pay, even if you're not doing the training, to have a policy, because you do want to explain there is a difference legally between what is legal harassment and what is inappropriate behavior regarding harassment in your company. Ideally, your policy is focused on the inappropriate level of things going on, that, this is inappropriate, you shouldn't be doing it, because you want to be able to deal with something before it hit the illegal button and just suddenly ended up in court. So you want to be careful and explain what constitutes harassment. There's a lot of confusion out there I've seen, because I do that training. And, and I know a lot of people think someone gets yelled at, it's a hostile work environment. Well, that's not true. And, so you have to really be clear about it. And that's why training actually does help. And, your managers need to know what to say and do. There's, times where I've heard of managers just kind of trying to blow off that employee. Oh, ignore it. He doesn't mean anything. It's like, that's not a legitimate way to handle it. So you do need to train anyone in a managerial position what they should do about it, even if it's just to say, that's kind of, it's like, it's even fine to say, I'm not quite sure. Let's go, I'll walk with you. Let's go tell, Sam about it over here, because I know he's the one that handles this for the company. I have a tendency not to have my policy say immediate. A lot of times we'll handle it immediately. I do say timely, because there are steps in an investigation that need to be taken. And so employees, truly, when you say immediate, often they're thinking, okay, within 2 hours, things are going to start happening here. And that may not happen. It may take a couple of days before you're ready to start to really have things noticeably happening. And so you want to be careful with your language, because an upset employee will take it more literally than someone else might. When you do have your policy should talk about California's laws. When they changed, they became very specific of what your policy needs to say. But the multiple choice for context, I think, is important regardless of what state you're in, because I've basically put my company as an alternative for small companies, because a lot of times the only one in management is the owner. And if the complaint is about that person, or if that person's not available, or perhaps doesn't handle it quite as well as you might hope, they need, you want to give them another choice. Because if you don't provide them with multiple choices of who they can let know about a claim, they will take it outside, and it becomes outside of your control, because you don't want the first person they actually can talk with to be an attorney. And you want to be able to take a look at it, see what's happening, get them, to understand you're working on it. And you can't do that if they immediately have to go outside. And frankly, they hear a lot of things on the outside about what they should do, what they could do, some that may be true, some that aren't. Something else to consider with your handbook policies, and harassment is one in California. They actually made it part of the law, to where whether or not you need to translate it. I have a few clients that have translated their whole handbook into Spanish, because they have a very large Spanish population in their workforce. And and the rule was when California actually came up with this, was the first time we'd seen anybody who talked about a translation being required. California's definition was, if 10% of your workforce speak another language at work, that is the language they're most comfortable with, and therefore this particular policy should be translated into that language also. So it wasn't even that whether or not they could speak English, it was, or read English. It was, if they're speaking this, on their own to each other, it's what they're most comfortable with. And to make sure that they understand a policy, then you need to translate it for them. And I've got a couple of clients, I've had a couple of clients that a large percentage of their workforce speak Spanish, but can't read Spanish or English, and don't understand English. So it becomes a whole nother thing when you've got that kind of thing. But it is important to understand that if you can't be confident and guarantee that your employees can understand what you've given them, you're going to make it a harder case to ever defend yourself in anything from an unemployment hearing to a lawsuit. Because if you can't say we gave it to them in their language, we did training in their language or whatever, then it falls to you to show, well, they never really understood what the policy was. So keep that in mind, that there are things you have to think all the way through when it comes to it, because across the US, there's a lot of people speaking a lot of different languages these days. And so be cognizant of what your workforce needs to make sure that you can implement your policies completely. Handbooks really, really need a drug and alcohol policy. I get a lot of people that say zero tolerance, and I question it. And the same with medical marijuana now, because there's so many states that now have recreational marijuana available. There's also medical marijuana. So you need something that kind of says, here's what we're doing about this. And because otherwise employees will assume, I've had employees assume the medical marijuana card was like a get out of jail free. It's like, oh, I'm high because I've got a medical marijuana card. Well, the truth is right now, and I really hope that we come up with a testing policy for marijuana we'll call it influence in the body, because they, before the feds take it off their illegal drug list, because otherwise it's going to be very confusing out there for companies. Right now, the marijuana is on a federal illegal substance list. That means every company out there can still say you cannot be high with marijuana at work, even if you have a medical marijuana card. If that's, and I've got some clients who are easing up, they're not doing drug testing, including marijuana anymore. So you have to kind of figure out, what is your policy? What are you willing to do? What are the safety risks? If you've got people driving cars out there and it turns out that they're, high to where they consider just under the influence, it's just what they're under the influence of while driving, you could be in for a huge lawsuit, more so than if it was just a plain old accident. The same thing if you're in a manufacturing, environment where there's large machinery. I've got an aunt who spent her entire life at Goodyear stamping tires and rubber stuff, and she's missing parts of 2 fingers because the stamp machine got it. And so, it's like there's safety issues, and whether it's even just small handheld stuff, people climbing on ladders, think about all the different stuff. If someone is taking a prescription, my policy says if you're on a prescription that says this may alter your behavior or create drowsiness, I want to know. I want to know that they're on this prescription. Now, I don't need to know why they're on it. I just need to know that there is a potential safety issue here, and we might need to change their duties while they're on this prescription. Most prescriptions that have that kind of behavioral effect are meant as short-term drugs that someone's taking for a reason. And then, it's like CBD is the newest thing. I've got one client that has big, they do deliveries, a lot of trucks, they're under Department of Transportation rules, and which allows them to do random testing. And so every month they do like 6 or 7 employees get sent in for a test, and all of a sudden out of 6 of them, 4 came back positive. And they all swore, no, nothing. They've only been using this new CBD at the time. Well, it turns out that CBD, depending on how well it's manufactured and what dosage they're taking, could show up as a positive on a drugs test. So if it's well made, it doesn't do it, or if they're following the dosage recommended on the bottle or whatever, it won't test positive. But they need to understand that that's the way it works. So that was an education for me and my client when that started happening. I question zero tolerance policies. I have like an extra little clause I will put in, because when they tell me zero tolerance, yes, while you're at work, it's zero tolerance. But what about those company parties where suddenly you're bringing in booze? You're saying, oh, we're going to have beer and wine at the party, and even if you give out tickets, but it's no longer zero tolerance, is it? So I've got one clause. It's like, to me, the whole policy is zero tolerance, except here's the exception. I have an exception clause that says, if authorized by the CEO, here's what we will allow. Something like that. So it's got to be very specifically that the company knows what they're getting into, because there have been lawsuits against companies for providing alcohol at a company party and an employee getting in an accident afterwards. So it's not done without risk, but at least you need to make sure your policy covers all the stuff, because if you say it's zero tolerance and yet you are doing like a Friday night little happy hour, it's not if the company is providing or being involved with it. So you need to make sure your policy matches your behaviors. Number 3.
Okie dokie. Do you have a policy stating employees have no expectation of privacy? So it's either a yes or no question, and we have a couple of questions that came up, CJ. We have a question from a company in California. They have online trainings for anti-harassment. So how does the time requirement work with self-directed online training?
You have to be careful of who you're using, because I know early last year when this first came out, because I know I created my own online training, and it was so hard trying to find a platform where I could force the timing on it. And what I discovered was some of the resources I had been sending, companies to weren't set up like they should have been, because if a company can fast forward through it, it's not meeting the 2-hour requirement, and that is a requirement. and, or the 1 hour, whichever one you're doing. So you have to be careful that there aren't those things, like with mine, it's got to be interactive. And so they have to do things. I think, Deb, you've got your mic still on. I'm hearing noises. And so we would find out that, oh, they like, whizzed through it in 10 minutes because all they had to do was hit it on fast forward and it went forward. The training I developed, they've got to actually stop and answer a question before it will move forward. But I have to admit, I spent a very long time, like 2 whole months, working on this stupid thing, trying to get the timing right, because of like, all right, if they take an appropriate amount of time, to do it and stuff like that. But the requirement is 2 hours. I know there was one DVD I had a client get, and she contacted me after. She goes, "This only lasts 88 minutes." And I contacted because I actually knew who had made it. I know the owner of the company that does it, and it's a big online company. And I asked them about it, and they said, "Oh, well, that DVD is meant to be with a trainer to just give them something to use and show people, not to be the entire thing." And it's like, oh, would have been good to know. So you have to be very clear about what it is you're looking for and double check. I mean, go through it, see what it takes for timing, and for some employees, it may take longer than the 1 or 2 hours because they're answering the questions more slowly. But it's when you're doing online, that's the best you can hope for, is that it takes them a little bit longer, not less time.
Okay, and the reason my mic was open was because we were still on the polling question. So we do have another question that came in, but I'll save that for next time. Since
Okay.
Yeah. So we have 35% say yes and 65% say no.
You really want to have that because that clause has come up in a lot of court cases, or that idea, we'll say, that that maybe you've got cameras in your facility and nobody knows about them. If there's no expectation of privacy, you are less held to the responsibility of informing everybody of every little reason that you might be looking at them. In the same way, like an electronics policy, that you give them phones or the computer, and you've got email. You want that right to be able to go look through their emails, to look at their online searches, what they're doing out there. I mean, I've worked with IT people, even when I worked inside 20 years ago. It's like our IT guy, he had the responsibility of looking to see what people were looking at online to make sure they weren't going out, looking at the porn sites. And we actually ended up with a director who was, looking at his porn site, looking at porn sites when he's supposed to be working. And when I asked him about it, he said, "My monitor's not facing out to my, out where people can see it. So what's the problem?" Well, okay, there's a problem right there that he would ask that question. But, you want that clause in there that they should not expect any privacy when they're using work equipment, doing, on work time. And because it is going to protect you in a lot of different ways. You also want to make sure you've added the good old NLRB clause. This is the National Labor Relations Board, federal agency who once upon a time was only focused on unions. But my personal opinion is, as the unions started to die off, and in the last, 10 years or so, they have now changed their focus to employee policies. And in the handbooks, I've seen weird statements coming out of it, and they are only subject to, I think they only report directly like to the president or something. And so there's no overseer group that can actually tamp them down. And I would see articles that say, okay, they've like overreached again and caused did a lawsuit about this. I saw one where a company was hit for having a policy that basically said you are supposed to have a, it was like, kind of like keep a smile on your face kind of thing, a pleasant thing. And it's like, well, this was, they made it into something that was bad and they did a lawsuit for it. And it was like, whoa. And then there's this wonderful, phrase they've got, concerted activity. And, so that when someone starts moaning and groaning about your company and how awful it is, or their supervisors, and even doing it on Facebook or any other social media and stuff like that, the general opinion from attorneys has come back is like, well, if they word it in such a way to where they're inviting comments from their coworkers, it's protected language. by the NLRB and their concerted activity. And you can't do anything about it. You just have to ignore it and hope other things happen to give them something else to write about. And because I've even had where, oh, I wish, my supervisor was murdered and stuff like this. Attorneys like, ignore it. But you need a clause in there that says anything you're doing isn't meant to, I have a double to avoid in there. It isn't meant to avoid concerted activity. It's like you can still do it, but you've got other policies, because a lot of times you'll have like social media policies and such under your electronic communications. So do realize what your policies are, and that you can't have it be too rigid when they're talking social media. Also, your electronic communications policy should talk about any kind of tracking you're doing. A lot of companies now are using phones, whether it's their personal, an employee's personal phone or a company provided phone that lets the employee log in, for the timekeeping purposes or other things. Some companies even put a GPS in the vehicle if it's a company vehicle. And one of the things in California, and it may be in other states too, is that this started bumping against personal privacy laws. And so then we came out with a new ruling in a court case that said, all right, if you're doing GPS tracking, you need to tell the employee how they can turn it off when after work, and then how to turn it back on before they're ready to clock in for work. And, and so that's important too, to kind of make sure they understand that, and that you're giving them their privacy when they should have it. And I know there was, even with cameras and stuff, there was a court case about someone who had changed their clothes in her office thinking she was private, but apparently the company had also put a camera in her office and she didn't know about it. So that's where these policies, on making sure employees understand where their privacy begins and ends is important. There are now have been court cases about the company use of personal cell phones. And the court case that said, even if the companies or the employees on an unlimited plan and it's not costing them more to use it for business purposes, the company is receiving a benefit by not having to pay for a phone and a cell plan to give the employee, and therefore you should pay an appropriate amount to the employee for this benefit the company is getting. I've talked to attorneys about it, and I had one client who, I swear, the employee had to use it maybe 5 times in a month. And he says, for something like that, paying the employee $5 a month would be just fine. You just want to make sure it's like, if there is no standard, it was a negotiation, kind of like, all right, we know you're using a lot, so we're gonna give you, $50 a month, or, stuff like that. If you really wanted to, go to the trouble, you could have employees bring in their cell phone bill and circle it every time they used it for company and truly pay an actual amount. But I don't know anybody who wants to go to that work. So usually they just negotiate amount or offer an amount to the employee that seems fair. And our next polling question.
Okie, what type of disciplinary procedure do you have? Discretionary, progressive, or you're not sure what the difference is? CJ, for reporting harassment purposes, should there be a designated female employee, even if that female is not in management?
No, there doesn't have to be a female. It needs to be, technically, it depends on the state. Like California, they can actually make the initial claim to anyone in a supervisory position. It doesn't have to be straight up the line or any specific person. But your policy should state like who's going to handle it, not just who you report it to, but who's going to handle it. And so it might be, a lot of times it may be just your HR manager. It could be outside investigator. It could be, CEO or owner of the company. It's the person who's going to be in charge of it, which it doesn't, so far none of the laws have stated that it needs to be a male or a female kind of person. It's more who is knowledgeable enough to be able to manage it and know how to treat an investigation, things like that. So it's based on knowledge, not on gender.
Okay. And as a follow-up to our last question, we have an attendee that is telling us that the state of California now has a preventing harassment training available?
Yes, they do. They've actually had they when California did the law, they had said that they were going to. Part of the thing was that the state was going to also create their own programs people could use for free. The supervisory one, they did have a PowerPoint slide, which is extremely dry. It's got some great questions in there, but it's extremely dry, and nobody I know uses it because it doesn't add the personal touch, so it's painful. And when they finally delayed, the due date, because it was originally that you had to have everybody trained by last December 31st, and then they moved it out because the state still had not done one. I've had varying opinions of the state version, to where some companies won't use it because they feel they stress a little too much on helping the employee file a lawsuit. And so I've had some companies that have talked with me about mine and say that they won't use that because they've had employees go through the program and immediately file a claim. And it's like you're supposed to, provide the employees the information, but apparently the state and even the California Chambers versions are a little more pro-employee than most of the companies are wanting. So it is there, but it is for free. So it is available. And if you've got no other resources and want a freebie, then that's a great source. But also check with your insurance carriers. Many insurance carriers are signed up with somebody or another who has the training also, and they offer that as a resource for companies. So, look and see what all the resources are. It's not always having to pay for it, but it does need to be done by somebody who knows what they're doing. You can't just take something and throw it out there, because the law does also specify you need someone available to answer questions for 48 hours after the training. And that's one of the things some of the online ones don't offer. All right. How's our poll doing? Deb? We lost her. Deb? Okay. Well, I don't think I can close the polling on my own. I think it has to be her. But let's see. Nope, I can't close it. All right, let me try. We'll see if anybody can see, oops, my next slide until Deb comes back online with us. Maybe just let me know. Can you see my disciplinary policy slide? Somebody type in the chat box that they can see it. Boy, am I the one offline? Okay, now I'm worried. Hello, hello. I'm not sure what just happened here. Oh. Okay, I don't know what's going on here. I'm not getting any responses to my comments and nothing. It looks like it's changed on my side. Huh. Well, I seem to be stuck in no man's land
Hi.
here.
Hi, this is
Hello.
Phaedra. Hey, I hear there's a little bit of technical difficulties and the system's being a little wonky, so
I know.
I'm
I was
gonna
trying to figure out what was going on here.
well, I'm
I'm
gonna
like,
pop in
nobody's
and
talking to me.
see if I can help move this along here. So we still have some attendees. We actually still have quite a few attendees.
I
So
know.
if people can click on a poll, if you can see it, great. If not, that's completely all right. I am going to leave the poll up for just a second, give people a minute to click, and then I'm going to go ahead and close it. It's been a while since I've run one of these, so give me a moment here. I'm going to go ahead
Okay.
and it looks like right now on this poll, we have 19% of our attendees feel it's discretionary. Oh, 20, 42% feel it's progressive, and 38% don't know the difference. So I'm going to close
Okay.
that and we can proceed.
Thank you. Okay, so sorry about that, guys. All right, a disciplinary policy. Let me describe the differences because it does make a difference in what you're doing. Discretionary means that you are picking the disciplinary action based on what happened. That's my favorite because there are some things that I consider that are ready for immediate termination and other things that maybe just you want to do a warning on or something like that. Progressive means that you have to follow these steps no matter what happened. Here it is. Step 1 is a verbal. Step 2 is a written. Step 3 is a warning, and stuff like that. And you have to follow all of those steps no matter what the situation. That's kind of the old school version, and I am not a fan of that because of the fact that I do think I've seen situations to where it's like, no, no, no. At the very least, this is on, a one-time warning, and then they're going to be terminated if it happens again. So I want that freedom to make those choices. So that's the difference between the two policies. So when you're listing what is in your disciplinary policy, as far as like, here's things that may be cause for discipline, make sure you're using language that says including but not limited to, because it's not ever going to be just those items you manage to list. There's always going to be other things that might come up. So you want to give yourself that opening so it's not looked at to where, well, you never said this could happen. And then I always like to say, a violation may lead to disciplinary action up to and including termination. And I've used that, the last half of that, particularly on a lot of things. On warnings, I put it on there. On performance improvement plans, I'll put it on there. But any policy that you're very, very serious that this could go direct, to termination, I'm going to make sure that they're warned. You don't want to be overly detailed with your disciplinary procedures. It's like if you're doing the progressive, you probably need to be detailed because that's where I've seen it most often is like it lays it out in the handbook. It's on the forms that they use, stuff like that, that it actually says, here's the way this works. And like I said, it's kind of, I call it old school. That's not to be offensive about it. It's just that in the, 40 years ago, particularly when it was all big companies and stuff, they all were using the progressive method. It's just been, in the last 20 years, I think, or even 30 or 40, it's been where discretionary has taken hold and become a feel better. It just feels better to use it because if you've got a situation, you're not locked into what you have to do. You can choose what would be best as long as you're consistent in how you deal with different things and what the discipline is. You can't fire somebody for doing something that the next person who does exactly the same thing only gets a warning. So, it kind of depends. And I think sometimes the progressive is meant to make sure everybody's doing it properly, but it has its own problems. Make sure your time off policies are in writing. I have to say, I have seen some handbooks done by payroll companies that offer, like HR components that have done. There's one particularly that's a nationwide company that for a long time, every time this attorney I knew walked into a company and found out they were using that payroll company, they would bring me in to redo the handbook. because literally there was one I remember where they told me, it's like, we can't understand what we have for time off. And when I looked at it, frankly, I couldn't tell what it was either. It was so unclear or so generic that you couldn't tell what the rules were. And so you want to describe that. A lot of states have paid sick leave now, required paid sick leave. And in California, there's 30 different local laws about sick leave. And, that become problematic, but you need to know what in your state and in your city might be a law and make sure that you're clear about it. And, like I was in San Diego. So in San Diego, we had a city law that was different than the rest of the county. And so the rest of the county was following state law. We were following city law. So it was really, you have to be aware of these things going on. You need to make sure that any kind of vacation policy you have talks about whether they're earning it or using it, if there's advance notice required, and it's one of those things that you kind of learn that some of these policies are needed when you start having problems with how people are using a policy, a benefit, and it wasn't clear. Personal holidays, my question would be, in personal holidays where often you would see, okay, we've got these paid, regular holidays that are, honored by most companies. We've got vacation, and then we're going to give you 2 personal holidays each year to be used as you choose. Well, you want to double check whether or not that's still legal in your state. I know in at least one state where a court said, the personal holidays sound a whole lot like vacation. Therefore, once you've given them to them, it is the employees. You can't take it away. So you're going to have to pay it out or let it roll over. And, so be very aware of anything that you're giving employees to look at that. I've even seen where like a policy that said they're front loading, the vacation or sick leave that we're going to give you the whole year's worth on January 1st every year. And I've seen lawsuits to where someone who comes in September is being forced to give them the whole year also, especially like vacation. It's like, well, you don't say, or someone who, it's like you maybe have them work a year and then you give them the vacation. And I've seen a lawsuit that said, well, they worked part of the year, they left before the full year and you didn't pay it to them, but they worked 3/4 of it. And according to your policy, it sounds like they might have earned some of it. Earned is a word that's used in the legal mindset as belonging to the employee. So be careful of your verbiage. This is why it's always good to have somebody who knows what they're doing, work on those handbooks or on those policies, even to have legal review of it to make sure that you aren't using a word, really a single word, will versus may, earn versus accrue can make a world of difference when you're fighting in a court to do that. And please make sure if you have under 50 employees or don't yet, because it's 50 for 20 or more weeks, in the current or previous year, make sure if you're not truly eligible for Federal Medical Leave Act, that you're not putting a policy in the handbook. Because if that's in the handbook, which I have seen in companies as small as 5, because they kind of copied the handbook from their previous employer who was larger, and now they've brought it to a small company, but you make the company subject to it if you put it in your handbook. Because you said, here's our policy. It didn't mean you had to have it, but now you put it in there and you have that policy, whether or not the feds would have forced you to do it or not. So be careful on what you're doing. Probationary periods. Please understand a probationary period, which is usually going to be, there's 2 ways it's used. So language, some people are now calling it, the onboarding period and stuff like that. But probationary period can be used either as the new hire 90-day period. Please understand that that's like a common theme for that being, let's test each other out, see what happens. And I do keep those in my handbook. I don't necessarily call it probationary anymore. It's more like, onboarding or orientation period, something that is talking about, this first 90 days, because an interview can only take you so far. And then you need to see people in the job and how they do. And it goes from both sides. Maybe the company or the employee doesn't like the company after all. And so, you want to include, I do include a phrase that says, it depends on what's going on, but, this period may be extended beyond 90 days. Keep in mind legally that 90 days is nothing. It really isn't. It provides you with no extra protections for firing somebody than it would if they'd been there for 3 years. What it is a time frame that just reminds you to keep an eye on this person, because frankly, it's easier from both sides. If it's not working out, that you move them out and find somebody else sooner than later. And that's kind of what it's meant to do, is look at it. Don't say you're going to follow up or issue some big proclamation that they've successfully passed their probationary period if you don't do it. Again, make sure, your words in the handbook or in your policy match your practice. And keep in mind that difference between a probationary period if you're doing a performance improvement plan. Often that's considered a probationary period also. So you might want to consider changing the language in your handbook to quantify it as being strictly that first 90-day period, so that there's not confusion when someone says, I'm on probation, what that means to them or even to other people. And next polling question.
I'm back. Sorry about that. The GoToWebinar application totally crashed on my computer and on a second computer. So I don't know what happened there, but anyway, I'm back. So our polling question: does your handbook explain when they are paid? Yes, no, or not sure? And CJ, in a probationary period, in an at-will state, do you need a probationary period added in an at-will state?
I think, like I said, at will, I think everyone needs to keep in mind you want at will language in your policies and your offer letters, but it has become something of lip service. You need to have it in there, but on the other hand, you can't just rely totally on that and expect not to get some claims, because people want to know. And so typically, it's like, yeah, you have at will, but I still believe that there's a reason you're letting someone go, because that's usually when it comes up. And so I always tell my clients, it's like, let's talk about it, see what's going on. Let's use the most legal, simplest reason we can come up with and keep it focused on that. Sometimes it might be an accumulation in that new hire period of that first 90 days. It might be just that, I'm sorry, you don't have the skills that we thought you might have for this, and we really need those, or, things like that. But you want to be able to give people a reason other than just saying, oh, we're going to use our at will option here, because
Okay.
people flip out and make up reasons then on why you fired them.
Okay, and I think we should save the rest of the questions until after the session today, since we lost a little bit of time due to technical difficulties. And on this one, we don't even have 70% of the people voting, but I'll go ahead and read the answers anyway. 81% say yes, 12% say no, and 7% say not sure.
Okay. So let's see, which was, okay, how are they paid? All right, what I'm looking for in a handbook, somewhere in there, I actually have 2 different sections I put similar things in. One is you need to be able to define the workday. What is the 24-hour period you're looking at for a workday? And what is the work week? What is the 7-day period you're looking at? The 7-day, that work week, in California, the work day comes up for overtime, but for all states, the work week absolutely comes up when you're paying overtime, because there are laws that say, if you work, more than 40 hours in a week, well, you have to define what that week is in order to know, prove that you're paying overtime properly. And so and it varies. Most companies will go with like the, 12:01 a.m. to 11, to midnight, or midnight to 11:59. That's their 24-hour period. I've had a couple of clients that we moved to like 5 a.m. was the start of their workday, because they actually had some employees who did work beyond midnight on a separate shift, and that made it easier to break apart the day for them. And then work week, it's like, all right, if you often have people working during the weekend, decide, is it better to have Saturday maybe be the start of your work week? So by the end of the regular, by the end of the, I don't know what to call it besides work week, by Thursday or Friday, whether or not those people are being moved into overtime, and you might let them go early instead of having them pay, paying overtime. So you want to define that because you need to be able to be very clear about when overtime, is counted. When you're calculating overtime, it's also important because I get a lot of questions on this, even from people processing payroll. Only worked time counts toward overtime. So again, put that in your handbook or in the policy that says, only work time. So holidays don't count. Sick time doesn't count. Vacation time doesn't count toward overtime pay. It's only for time they actually worked. And if you want overtime pre-approval, make sure that you've specified that. Otherwise, employees just working overtime without a thought instead of getting permission to do it, because it does cost the company extra, and it can cost. I've got a client with, what do I have, 12 employees, and I've just started dipping into their payroll to take a look at it. In the last 2 months, he has paid $6,000 in overtime alone because no one's tracking it. No one's paying attention to it. And they don't have a policy that says they need pre-approval. That's a huge hit to, a company's budget. And then you need to also define, to me, I also put in there when employees get paid. So, if you look at the employment law posters that go on the wall, there's often one of those in there that says, what day of the week are they getting paid or how are they getting paid? So it might be you're paid bi-weekly, every other Friday, and it's 1 week in arrears, which means that if you work this week, you'll get paid for it next Friday. You want to be clear on exactly when it is because people want to be able to look and see how they can plan for when they're getting paid. And most states have laws that say, if you've told me I'm paid on Friday, you absolutely have to get them a check on Friday. You can't say, I've had clients where it drives me crazy. They're like, oh, we forgot to submit payroll on time. It's going to be, a day or two late. That's fine. The employees don't care. It doesn't matter if the employees don't care. Often the state or the federal government cares for them, and you'll get penalized for it. There's only a few, things you can do, like if you're paying semi-monthly, so you're paying twice a month. Sometimes a holiday will kick in to where it screws up your whole payroll system, but you need to plan for that. In California, the only choice you get is you can tell the employees going forward, you will always get paid the day before a holiday or the day after if the holiday falls on the normal payday. And you have to plan your payroll and submit it accordingly to get it paid on time, because there are penalties for not doing that. Minutes count. So yes, we're running out of time, and I'm really sorry here. We've still got several things, but I'll try and hit the primaries. Keep in mind, if you've got grace periods, if you're doing rounding has seen several lawsuits. The closest we've got now is that there has been lawsuits where the judges have said if you're keeping it at 15 minutes or 12 minutes or something, that can work, but you have to actually be able to prove the employee over a long period of time would not lose time. So once in a while, you have to actually audit it and double check that. Make sure, if you're in a location like California, counts every minute worked. So if an employee checks their email after work, technically you should pay for that time. Federal government said, these odd minutes we don't care about, but different states treat time differently. If you're following state or federal policies, it's not an issue, but if you've got some state policies, you better know what they are. Sorry. Meal and rest breaks, are they required in your state? Are they required? California is like the nanny state, which we all know, and it's got very specific rules for when people take their lunch. But make sure that, your state, if it requires it, that you're following, and that's only for hourly employees, the non-exempts. Exempt people, I don't care what state you're in, they don't care if you ever eat or sleep. You just do the job. But the non-exempt are more protected often and have specific rules. Free speech. This is another thing where people say open door policy, but they don't really mean it. You need to provide a way for employees to bring you their concerns. If they've got an issue with something, not just harassment, but if something else is, a problem, you want to hear about it because you want to be able to address it and either clear it up in their mind. I just dealt with one where this employee realized the company was not taking employee share premiums out pre-tax. And, and it's like legally you don't have to, because IRS has a special code for it and all this kind of stuff. And the company wasn't doing it. They've chosen now to go ahead and do it, but they hadn't. And now this employee's like, oh, you need to make it retro and stuff, which isn't legally possible. But it had to be explained. Here's the way it worked. They were doing everything legally before. We are going to change it, blah, blah, blah. So, and there's some things you can't prevent employees talking about. That's where that National Labor Relations Board will come in, things like that. Employee complaints. California specifically has a law that says you can't prevent employees from talking about their money with other employees. You can't ban employees from talking about unions, terms and conditions of employment. That's all that stuff that the NLRB is protecting. Sorry, I'm talking so fast. Make sure that you know what leaves your company is subject to. There in California, we have so many leaves now. I mean, I've got one of my employees who deals with that, and she's had to develop this whole chart to keep track of all the overlap and how it works and to be able to explain it to employees. And I only did this a few years ago, but I've got this about your leave section now in my handbook that says, all right, you're going on a leave of absence. Here's the things you need to know about. Here's what happens with your insurance premiums. Here's what happens with any vacation or sick leave accruals. Here's how much we want you to communicate with the company. Here's what we're going to do with company property. Here's what we want to, what we're going to expect from you before you return to work. Lay it out for them so that they're clear, because a lot of times your supervisors won't know, and it makes it easier to implement. I've actually told my clients, somebody goes on a leave that's more than 2 weeks long, we're immediately picking up any company equipment they have, because somehow if you wait and find out it's going to be 2 months, 3 months later before they come back and you go pick it up then, they inevitably believe they've been fired, and it makes it messier. So I think, if the leave isn't meant to be more than a couple of weeks, you let them keep it. If it's longer than that, you may need to get someone in there to fill in for them, and they need that equipment. So just make it, clean, and figure out what you want employees to know and what you want everybody to remember when someone's out on a leave. And we're going to skip past this. Field employees, this has never been more important, is to look at field employees. You've got people in the field, construction companies. I've got a lot of different clients with different people in the field, everything from sales reps to construction people that need to be able to know how to do different things. What are you doing, like, especially if you've got construction or something where that job site changes for them? What are your commute rules? How do they submit time cards? How are they seeing the required postings that legally in every state, whether it's the federal posters and stuff like that, every state's got posters and stuff that the rule is employees must have access to that information. How are you making sure that happens? A lot of field employees don't have computer access. I've had some clients where we print out all that stuff and put it in a binder, and we tell them it's like it will be behind the front seat of the supervisor's truck on the job site. Some clients have a big box they keep on the job site, and they can keep it there. But you need to have some place that has access. And now we've got a ton of employees working remotely. Right now, it's been what I call the Band-Aid principle. It's like whatever you can do to get the people to be able to work out there remotely, because some companies you can't come into the office. So, but as that goes on, and some of my clients are saying, okay, this has been working, we're going to keep a lot of these positions remote. Well, now I'm going to be pushing them to do a more formal policy on it. What is the eligibility for remote work? What are the hours, and how are they tracking time? How are they doing remote access? What is the security? 40% of, let's see, I read this, home computers are 40% more susceptible to hacking than company computers because of the different security home computers have. And it's not just, the online security, it's truly that they can come in through your internet service and get to you. So there's that kind of concern for the company side. Do you have an ergonomic office? Do you, I've had a couple of clients where you take a picture of your home office. We want to make sure you're actually able to do this and not just sitting on your sofa with a laptop. It's like communication is a huge thing on when you start working remotely. So there's a lot of little things, and there may be some very specific state and local laws based on their home location to where they're not even allowed to have a home office. So you want to look at all that kind of stuff. And the biggest thing to keep in mind right now, when you've got people working remotely and you've got laws like, I'll take California since I know it's got like 30 different, localities with different laws. If I've got now a employee working in a different locality, or even I've seen some employees like go home to another state to ride out COVID. And now suddenly they're subject to the laws in that state, not your regular laws. So you look around and where all of your employees are located, they are subject to the laws for where they are doing the work, not your home office. Now, if it's just this temporary thing where you've sent them out to do a job and come back, that's different. That's the home office is still their home base. But if they've got a home office, that became their home base. And now you might have different laws you're looking at. I don't know if you want to put all that in the handbook, but at least you need to think it through. Health and safety, you need to include things, summertime, heat illness, ergonomics, smoking. What about employees that drive? Are you making sure that they're safe to drive for your company? Do you have a policy now about pandemics in general? Even just a small thing that says, if a pandemic hits, you have to follow our safety protocol that, is a separate document, blah, blah, blah. And, and to reference any full documents you have, like a whole safety plan, things like that. I know, I'm sorry, I'm whizzing through this stuff. Dress code, be very aware of what your dress code says and make sure that you're avoiding all of these things that are out there now. What are you saying about tattoos and piercing? Are you, uniforms? Some states, you're required to pay for anything you're requiring the employee to wear, unless it's something they would have and own anyhow. So be conscious of that. Okay, and then include a disclaimer that it's meant to be a guideline. It's not an employment contract. It's not, every little detail that you can think of, and it can be revised. And if you do a translated version, make sure the English version controls if your company is basically, at least if that's where it started. If it started as an English version, it should be the controlling document because you might not have translated something correctly. So make sure that you've got a control listed there. Okay, we're skipping that. We already spoke about the translations. We're moving off that. And every version of your handbook should have a receipt that signs off saying, digital receipt, handwritten, whatever, that says the employee got this version of the handbook. I've actually had a client looking for a handbook from 10 years ago, saying that they just now got a claim on something in there and they needed to prove that the handbook version she signed off on it had this policy in there. And in their case, it was to be able to use their image and photographs and stuff like that. And we dug it up. So that would be the other thing. Hold on to all your old copies. Don't just discard them because they're old. They may come in handy if you ever get a claim. And then training. Make sure that, if you've made a change, you've told employees what are those changes, just even to highlights. We changed this policy, it was updated, we changed this policy. And, so that they don't have to look through the whole thing trying to figure out what you did different. But if it's a new handbook, brand new, make sure that you go through some highlights, the things that are most important to the company that you want them to know about. And annually take a look at it, go through it, make sure, it's like a lot of my clients will do a legal review if we know there's something that's changed, and then we talk. It's like, have you changed any of your other policies or your practices? Do we need to make a few changes in there? And then we go in and do that part of the update for them. But keep in mind, if it's true old and there have been some major legal changes, sometimes it's better to have no handbook than an old handbook. And, so if you've got a policy that had what is now illegal language, you don't want to be using it. Get it updated and then redistribute, because that could get you into more trouble than not having a handbook at all. Okay. Well, sorry, I didn't get it finished on time. All things considered, I think we did okay.
It's not your fault. I'm sorry that my GoToMeeting crashed, and it just at the wrong time too, with a polling question on.
I know, because I was trying to move forward without it, but I can't get past the polling question.
To do about that. So technical difficulties, for sure. So
all
do you
right,
want to handle this?
Yeah, I've got some time if we want to answer some of the questions that people ask.
And then we are recording this session, so if you have to pop off, we can make sure that we give you a link for a copy of the recording, and we will go ahead and answer the rest of the questions here. And we really appreciate your putting up with this today. So we have a restaurant specific, well, before we get to that one, there's a few questions on the alcohol related issues. So if the alcohol is not provided by the employer during an event, is it still the employer's responsibility to enforce the alcohol policy?
Yes, because the employer, I know this is out of California court, so it may play out differently in other states, but a California court said that the whole point of the party benefits the company because it's a team building event, and therefore the company has responsibilities, and that's the way they play it out in court. There's actually this weird law apparently that's called like something host. You're the something host, and so if you're the one that pulled them together, even if you don't provide the alcohol, you're still holding the responsibility because it was your event.
Okay. And in the restaurant industry, it's customary for restaurants to offer an end of shift drink to the staff. And they've never seen any information regarding this practice. Can you offer an opinion on that?
I think, here's what I think is that I would not do it because, or I'd change the language a lot to where it's more, that, I don't know. I'm not sure I'd even offer that because the problem is, let's say, okay, I personally have become sadly a very, very light drinker. So one glass of wine will be enough to make me slightly dizzy because it's just over the years I've brought it down to a level to where I don't tolerate it as well. Now I go out in my car and I hit somebody. I'll guarantee you the restaurant will get sued because they provided the alcohol at no cost to the employee. So because I've got a client that has a brewery and they were wanting to have a policy. Well, we want to have our employees, try out other breweries so they can, speak better about our beer versus someone else's. So we want to give them $100 budget, to go do this. And it's like, okay, so many things wrong with this picture here. First you're giving them money to go somewhere to go drink. So that's not good, and so I suggested instead they do kind of the bus tour where you see in some states where there's a lot of breweries or cities, they actually have these brewery buses that will stop at various breweries. I go, that's a lot safer, but then you still need to make sure they get home safely. Because I've even seen a lawsuit where employee went to a company party, got home safely, but then left again, still drunk, and hit another car, killed 2 people, and the company took a major hit because they were the party host and provided part of the alcohol that the employee had. And so basically and this was in California, and so it kind of became like, until that employee is dead sober, you are going to be held responsible. So there is a lot of risk there. You just have to decide how much risk you're willing to absorb.
Okay. And in this new era of digital equipment, is it okay to prohibit cell phones while at work? Can that be a company policy?
Yes. You can, I've had clients where we've said, you can drop them off at the reception desk or leave them in your car or whatever, or at the very least, they are turned off and in your desk and not to be seen. As long as, and then but you do the other side of it is like, if your family has an emergency, here's who they can call and we'll make sure they get in touch with you right away. Because usually there's company phones that they can use. It's just that everybody's gotten used to the cell phone. So you can certainly prohibit them. You just want to kind of make sure, because that's usually the number one argument that comes up. But what if my family needs me? Well, if the family needs you that badly, have them call the company. So give them a designated place that, number they can call to reach that employee through the company lines.
Okay. Now, when it comes to progressive disciplinary processes, if your handbook doesn't have one, does that really give you the greater freedom to act? A lot of people are saying they're not comfortable with that because it feels like it should be an all or nothing kind of thing.
I'm not quite sure I understand completely. Progressive, it's like progressive is truly where your policy states. It's like on the first, I knew one company where it literally, they had 6 steps before the person was officially written up And it was like, oh my gosh, these people, could do all kinds of things. But I've seen cases like I do put a disciplinary policy in there, but it's a discretionary policy, meaning that we will determine what the discipline is based on what the problem was.
Yeah.
Because I've had where an employee in the warehouse forgot to put a shipment away. And it was a $15,000 shipment that was supposed to go directly into the refrigerated area in the warehouse. And instead he forgot, that shipment went bad. Now, $15,000, it's like, okay, is that a simple verbal warning? Is that a termination? I mean, you kind of have, to me, it's like, I like being able to say, wow, that one's a final warning. It's like, yeah, he screwed up, but it wasn't intentional. And, but we can't afford another $15,000 error like that. So it's a one-time warning. The same with, oh, I forgot to lock the building when I left last night. Is that, oh, slap on the hand, gosh, shake your finger at them. You really need to remember to do that. Well, when, you get I've seen companies get wiped out. Literally, I had a client where someone forgot to lock up after they left, and someone didn't have to break in, walked in, stole a bunch of stuff out of the company. And it's like, okay, is that, that's why I'm not a fan of the progressive. It doesn't mean it doesn't have its place, but with most of my clients, I want the discretionary ability to say, wow, that was something else, we're not going to give that employee the ability to leave the building open again. We're going to, either maybe we're going to take away their right to be that late, that they can't be the last person out anymore, something like that, but to choose what is correct based on the situation.
Right. So in this case, the person that asked the question says that their company does not have a progressive discipline policy, and he has poor performing employees, and he feels like his hands are tied because the company attorney says it's better not to have a progressive discipline statement so that it gives him greater freedom to act just how you're describing. You let the punishment fit the crime, so to speak. But he doesn't feel comfortable with that. He feels like it's an all or nothing thing. So I think your explanation was a really good one there.
Yeah, I mean, I think, the problem is it's not an all or nothing. It really is. I mean, to me, I still have, we'll call it my own version of progression. Yeah, depending on if it's not a serious thing and it's just a regular disciplinary thing and it wasn't some big blowout $15,000 mistake, I might say it's like, okay, when I talk to a client and they're saying, okay, I'm ready for termination, it's like, all right, have you talked to the employee about this problem? Have you ever written them up about it? Is it something that should lead toward termination more so than just immediately, chopping block? And
Right.
that's where I think the company needs to be in the same mindset to where no, it's like we do have a progression of sorts. We're just not stuck to it.
Okay. And does up to and including termination, that little quote, exclude the possibility of litigation if an employee does something that warrants it, like stealing?
No, because even if you terminate them, and they stole something that is worth, going after them for it, or even talking to the police about it, it doesn't exclude that, because the up to is more like what you yourself can do as a disciplinary thing. When you take it outside, it now becomes a legal thing, whether it's civil court, police action, something like that. It doesn't exclude you from doing things. At least I've never heard that it does. And I've seen, I've been using this phrase for a long, long, long time, and attorneys have reviewed the handbook and have never thrown that up as a problem.
Got it. Do all available and eligible leaves of absence have to be listed in the handbook?
No, they don't. I tend to do it because I work with a lot of people who don't have an internal HR person, who don't know what the laws are. And so for me, a lot of times the handbook, I consider it also an educational tool for the supervisors and owners of the company, because I don't want a supervisor to say, oh, no, you can't take that. You have to work, and then find out the employee was legally eligible for it. But so a lot of times if I've got a clients, and I have had clients that don't want all of those in there, they're always afraid, oh, everybody's going to rush out and use all these leaves. They're not that easy to use, for one thing. Even in California, they're not that easy to use. And I think that the risk of having somebody find a leave that they magically can use that they didn't know about is rare compared to the possibility of a supervisor denying a leave they weren't entitled to. So at the very least, if someone's really trying to cut them down, what I will do is I will put just the titles of the leaves listed. And it's like, then just please see HR if you'd like to know more information about that particular leave. And then I give the HR or the owner, whoever I'm, doing that for, the fuller policies separately, so they can actually know when they become, applicable for the situation.
Okay. And is it okay to pay overtime when an employee doesn't take lunch?
It depends on the state. Yes. I mean, if they don't take a lunch and they work, we'll say 8.5 hours now because you expected them to take a half-hour lunch, or the fact that you expect them to work till 5:30, regardless of whether or not they took a lunch, then you are gonna, you can pay overtime. Like in California, you would be forced to pay overtime and a penalty for them missing the lunch, because California is California. Other states, it's usually only going to be looking not at the 8-hour day, they're looking at the 40-hour work week. I've never seen anybody, state or federal, who objects to you giving the employee more money than they might legally be entitled to. They're more concerned that you don't give them enough.
Exactly. So if you need pre-approval for overtime, but an employee works without getting approved, do you proceed with discipline?
Yeah, you have to pay the overtime if they worked it and it was owed to them, but then I write them up.
Okay.
And just say, you violated this policy. Going forward, we expect you to follow it. And, that's like just first stage, and see what they do.
Okay. Can field employees' access to required posters be electronic through like an employee portal?
Yes, if they have access to it. And so that's the big thing, is that do your employees in the field have, a smartphone or an iPad or whatever, something out in the field that they can actually utilize that? If they can't, then it's not sufficient. And that's when you have to look at some other possibilities. Keep in mind that those employment law posters that are up on the wall and your state ones, every little piece of that is available somewhere as a PDF.
Right. And for small companies with less than 10 employees, is it even advisable or necessary to have a handbook?
In California, once they hit 5, I start recommending handbooks, because California has a very strict pregnancy leave that hits companies at 5 or more. And so, I won't necessarily push it hard, but about 10, I think you want to start consolidating your policies into one document, which is a handbook. Because otherwise, I find that when you start getting 10, now you're getting different people hearing different things about rules and policies and stuff like that. And that's when it starts getting dangerous, and it's better to be having one document you can refer people to.
Okay. And we just have questions that keep on pouring in. I don't know how you want to handle it, DJ.
I'll keep going for a while. We'll try for a little longer.
Okay, back to the alcohol question. If coworkers get together for drinks after work and it's not a company event, but it's just a bunch of coworkers, is the company responsible if one of those employees gets a DUI?
No. Once they've left, if the company's not involved, because I've had, where, like a supervisor or something goes out with those employees, and as long as the supervisor's not looking like it's a company event, not paying for all the drinks and stuff like that, it's just coworkers getting together, then they're on their own and the company doesn't hold responsibility.
Okay. So if we are a department with less than 50 employees, because our company is large, we have FMLA in our handbook, but it doesn't apply to us because we're not within 75 miles and all of that. Should we even have that in our handbook? Because
you still want it in there, because you need it in there, because it's still the company policy. It may not affect your particular work unit because you're set aside and your employees won't be eligible, but they still must receive the FMLA paperwork saying that they are not eligible because they're not in a unit big enough for it. So it's still part of that law and it needs to be in there.
Okay, so in a really small organization, maybe you know, a small organization, how do you suggest employees bring up complaints about other employees when they might not feel safe to do so, or talking about other employees because it's such a small organization?
Yeah, that's where it gets really tough. In a really small organization, that's where it's helpful. I mean, I offer what I call the safety net for some of my clients that are tiny like that. It's like, let them know that we're out here and that an employee could call us. And yes, that we would bill that client for the time, but we rarely get calls, but it's more the fact that you've given them another option. I've gotten some strange calls. It's like, gosh, you know, aren't we supposed to get paid for Labor Day? And, you know, and it's like, I can tell them, it's like, legally, no, you know, it's like, even if the company closes, it's not, you know, requirement that you get paid for it. Oh, okay. And so you get the, you know, sometimes the odd questions, but, you know, if it's about another employee, sometimes I can just offer like, here's a way to maybe deal with that employee. I can, you know, talk to the owner and try and keep names out of it as far as like, is there some kind of training that you're willing to provide or this or that? But I think that's the downfall of many small companies. They don't provide enough options for employees, or I'd say resources for employees to be able to answer their questions or to bring up their problems because they aren't comfortable enough bringing them up with an owner. You know, in a small company, that's often maybe the only person you've got in a supervisory position.
Right.
And, you know, and so that does make it more difficult. All you can do though, if it's something, you know, I think if you can't deal with it on your own, maybe the only thing I can suggest is that, you know, the employee then just kind of goes to the owner and say, can I talk with you about, you know, figuring out better ways I can work with this employee, this coworker? But that's hard. And a lot of times those owners in the small companies won't know an answer for it. So
Okay.
I'd say maybe explore a possible outside resource that would be available.
Okay. In regards to vacation, is it okay to have a policy that is a use it or lose it policy, or do you have to have one that is paid out or rolled over?
It's going to depend on your state. California got rid of the use it or lose it years ago because the courts, you know, court cases, and this is where it falls apart for a lot of other states. And it's the court cases, some of them will pull in a court case from another state, depends on what your state laws are. But I know in California it said, no, once you have earned it, it is yours forever. You're either paid for it or you get to use it. It's not something that can just disappear, which is when California allowed us to start putting caps on how much you could earn so that it would stop at least how much, you know, the big liability out there would be. But check your state laws because it will be based on what the state law says about the vacation. But a lot of times, I think in most places, once you've earned it, it is considered yours. But federal law, I'm not quite so sure that it goes that far.
Okay. So CJ, we're getting questions about harassment, which is not this session, but it is, you know, regarding policies. Do you want to answer those questions?
Well, let's see if it's something policy related or not. So throw them at me and see what we got.
So it seems more specific to these organizations. A leader keeps verbally harassing her team members. The company wrote her up many times, but no action. Is this considered sexual harassment? And what is your suggestion on the leader verbally harassing her team members many times?
Okay, so this is where I mentioned, you know, that it's good for a policy to state, like, you know, have that break between inappropriate and illegal.
Right.
A lot of times that supervisor harassing employees, it may be if that person is kind of, I mean, I've seen some who just have a really lousy management technique, but it's not necessarily illegal. Illegal means that they're doing it based on one of those protected characteristics that are protected by the harassment laws. So if it's just a general that this person is like calling, you know, constantly berating somebody, but it's based on their work, not on their protected characteristic, it's not illegal. It's just a bad management technique.
Mm-hmm. Mm-hmm. And I think this is our last question. At least it will be our last question. This has to do with a policy that states that you have 90 days before your benefits start.
Right.
What happens when you have employees who are legitimately sick and taking off time within that first 90 days due to a legitimate illness? Does that count towards the 90-day benefit period? If they really have an accrued sick time, how do you work that out with them?
Okay, so some of this is going to be dependent on your state laws for like required paid sick leave. So I'll use, like I told you, California's got like all those different localities with different laws about it and stuff like that. But if we just look at the California state law, and because a lot of them are based on that, this localities all offer more time than the state did. So the way that it's said is that if somebody is sick in that first 90 days, it's like they start accruing that sick leave from day one, but they can't use any for 90 days. And what the state has allowed us to do in that first 90 days is say that if you're sick a lot, you could actually then go ahead and terminate for attendance issues. So that's one side of it, is looking at it from the legal side as far as the sick leave law. Is that you don't, because I've had employees that contact me like on day 100 and say, oh, this guy's missed 27 days. And it's like, oh my gosh, and you've still got him as an employee. Why didn't you do something while you still legally could? Or it was much easier because they weren't protected by the sick leave law. But so you've kind of got that, whether it's sick time. Now, if you want to hold on to the position, the person, if you, like they ended up in the hospital or something like that and just weren't this sporadic, thing that's, because I do believe what you see in that first 90 days, that's the honeymoon period in my mind. If they're not behaving exactly like you want them to, or showing you everything that you want for attendance and everything else, then you've asked for the problems you're going to have later, because they're showing you their true self there. But if it was a legitimate thing, they caught pneumonia, they got something that wasn't, just random stuff that drives everybody crazy for the sick days, then I would push it out. That's why I also have that little extra paragraph I only started adding a couple of years ago to my 90-day period, is that, we may choose to extend it. And that's when I would extend it. It's like, okay, you've been, sick 20 out of our 60 days or 90 days. So we're going to move this out a little bit further so that you've got time to continue showing us. So it doesn't need to be the exact day for day kind of push out. Just let them know that, we're still in our exploratory period because it got interrupted. And remembering also that interruption slows down their learning curve, because if they were working for you for, 30 days, we're out for 2 or 3 weeks for something legitimate and then come back, they're going to have to kind of start not completely over, but almost from day one again to remember all the stuff that they had been learning in that first month. So I would just push it out now. Then the problem is, though, when you say your benefits, it's only the introductory period you can push out. You can't push out the benefits unless you've got something written into each of the benefit policies. Sick time would not be one you could push out if it's part of the state, part of a state or local paid sick leave law. You can't push it out. It's day 90 no matter what. The vacation and stuff like that, you'd want to write into your policy if you've got an eligibility period of like 90 days that you're going to push it out. Same with like performance reviews. If someone goes on a 3-month leave of absence, I'm not going to give them a raise because they happen to work, it's like month 12 and it's time for a raise. Now it's month 12 plus 3 more months before I'm going to look at a raise.
Okay. All right. I thank you so much for putting up with my technical difficulties today, and thank you for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you, CJ Westrick, for your time and expertise today. We hope all of the attendees found today's webinar to be a valuable use of your time. And be sure to join us on September 22nd for conducting a facility security assessment without needing a security consultant. Thank you, everyone, and have a safe day.
Thank you all.